I'd like to welcome you once again in the second of our series of sessions, workshops rather, as part of the preparations for the IT law moot court competition in its first regional edition. My name is Abdurrahman Gamal Yaqub. I am the director of the moot court unit, the one responsible for the competition. And today's session will be conducted by my very dear friend and international lawyer, Mr. or Dr. Walid Al-Faras. Walid is an older friend, as you can tell from the earlier side talk before the beginning of the session. Firstly, let me tell you that today's session will be all in English, unlike last time. So that gives little space for maneuver for Walid, as I'm sure he'll be able to manage, because I can see friends here from non-Arabic speaking countries. I also would like to congratulate the Muslims among us for the coming of Eid al-Adha. Inshallah, it will be a blessed feast and a happy time spent with your families and beloved ones. I would also like to remind us all that this workshop, as well as the competition, and basically everything in that regard, is part of our endeavor in Egypt, in the British University, and in the unit to raise awareness of the most relevant legal issues given the ongoing appalling atrocities in Gaza. We hope that these efforts help to educate and raise awareness to the legal to the legal field, to the legal practitioners and students, and to the public in general. Let me not take much more time. I'll now introduce our speaker for today, Mr. Dr. Walid Mahmoud Al-Faras. He will be discussing today the topic of classification of international humanitarian classification of conflicts in under international humanitarian law. Walid has a master in legal research from the University of Utrecht in Netherlands. He is carrying out his PhD in international law at the University of Ghent in Belgium. He is as well a lawyer and a consultant, international consultant, specialized in international criminal law and international human rights law. He acts as a consultant to several international organizations and universities and ministries of justice in different countries. And he has an extensive experience in mooting, starting as a mooter himself in Price Media Law Moot Court competition in 2013, if I'm not mistaken, and that's the context for how we got to know each other. And he acted along the range of mooting roles: a participant, an organizer, a judge, and a coach, of course, the recent of which was his role as a coach of Ghent University team participating in the competition of the International Red Cross Organization. Walid, you'll have to excuse me if something has slipped through. I just want to remind you that just like last time, the session will not be interrupted. Walid will be speaking for 1 hour. Participants, if would like to raise questions, that will be through the chat box. We will collect questions and will deliver them to Walid at the end of the session after the end of that 1 hour. And for 15 minutes, he will be answering the questions. And if needed, we can allow a voice question. I think that concludes my part so far. Walid, you have the floor for the upcoming hour.
Thanks, Abdurrahman. Thanks for the introduction. I'm certainly still is a Mr., not a doctor, because I'm still doing my PhD at the moment. So formally, I'm Mr. You can actually also call me Walid. I'm fine with that. Thanks, Abdurrahman, and I voice what you said. Happy feast. كل سنة وانتم طيبين. Sorry, we're taking you from your loved ones at the moment, but I think the topic of today is both very relevant because, as Abdurrahman said, the situation in Gaza that is taking place for a while now, other situations of conflict. It's basically a topical kind of topic. So that's one, and two, it's part of your moot court. So it should be useful, and for me, IHL is basically one of the most coherent laws, or one of the most interesting, with a lot of information data. It's really clear, so it shouldn't be impossible to cover it or cover certain aspects of it today in this 1 hour. So without further ado, I would like to get started with the topic itself. So today you should think of international humanitarian law as, like, think of this session as a crash course. So we'll try to cover from A to Z, but at the same time, we will focus certainly or solely on armed conflict. And as Abdurrahman said, if you have any questions, just drop them in the message box. And at the end, which is an hour from now, we will tackle them one by one. Okay, so I will get started with these slides. Yep, so international humanitarian law is essentially about wars. It's a law that basically organizes the armed conflict. So it should be seen as a law that is of eternal relevance, because up until now, we could not manage to stop wars. There are other legal regimes that organize that when and when not a war is legal or illegal, and this certainly tries to diminish or decrease the amount of armed conflicts that take place around the world. But once an armed conflict started, and this is what we will talk about today, we have rules that organize the armed conflict. So the idea is that even wars would have rules, would be covered by rules. See, objectives of today would be to define IHL, like basically tell the characteristics of IHL in general, the main idea from which all the rules and all the principles would stem from, and the place of international humanitarian law, or I would be referring to it as IHL, the place of it in international law in general. Second, we will clarify the main legal sources. So for you as mooters or as practitioners in the future, inshallah, you will be relying on the sources of IHL, which would be the binding norms that you would use to give meaning or analyze a certain situation from a legal point of view. So we will navigate that and try to sketch them one by one. And as I said, whenever you have a question, just drop it and we will engage with it at the end. The third thing, which is basically the essence of today's presentation or lecture, is to identify the situations in which there is an armed conflict. So when there is an armed conflict, of course, if you would like to apply the rules of armed conflict or IHL, then you would certainly need a situation of armed conflict. So this is what we're going to talk about. We have two types of situations as I will introduce. International armed conflicts, which I would refer to as IAC, and non-international armed conflicts, which I will refer to as NIAC. We will try to also look at the scope of application. So when the scope, the material scope, geographical scope, when, or basically the jurisdiction of IHL. When does it apply? Where does it apply? To whom does it apply? We'll try to cover aspects as much as we can. So international humanitarian law. We first have to give some meaning to what we mean by international humanitarian law. And for those of you who already started working on the case and reading the case, trying to make sense of the applicable regime of IHL, and which would be very new to some of you, you would be struck by a lot of terminology. So I thought to start from the beginning. Usually IHL is referred to in certain ways. So you would see it written as IHL or International Humanitarian Law. You can also see it referred to as humanitarian law. So these are basically the easy terms, or what we would usually hear. But IHL is also referred to as the law of armed conflict, the law that governs armed conflict, or as the abbreviation to armed conflict here would be LUAC, or the law of war. It's also referred to in Latin words, which is jus in bello or jus in bello, however you pronounce it. And any of these terms would refer to the same body of law, which we will flesh out today. So whenever you hear jus in bello, law of armed conflict, you simply know that we're talking about IHL, the rules that regulate armed conflict. Okay, so also if you look at these terminologies, you would figure out that humanitarian law is more a terminology that signifies the humanitarian aspect of the legal regime. And if you look at the law of armed conflict, you would realize that this signifies that there is an armed conflict. And the reason that there is a difference is historical. So initially, the law of armed conflict used to be more about understanding military necessity, understanding the realities of war, and then saying that there are rules or law that govern armed conflict. And over time, this bulk of law started to look more humanitarian in the 1970s and forward, due to the human rights movement. So you would see that the law has become more humanitarian as well in substance. So this is some explanation about these different names, but they all refer to one legal regime. If we will look at the three words that exist in international humanitarian law, we would find that it is international. International means that it is a law that regulates the relations between states, or states and international organizations, or other subjects of international law. So it's basically a branch of international law. That's what the word international signifies. If you look at humanitarian, you would find that it is a law that revolves around humanitarian issues, which could be access of humanitarian relief, would be civilians in need, basically disasters in times of armed conflict. And then we find the word law, which signifies that it is a body of law, which means perhaps treaty law or case law. So it's a set of rules and articles and a set of principles, basically. So this is, if you read the word, or if you refer to international humanitarian law, these basically would be the meanings that would come to you. But it is also much more nuanced than that. So if you look at the first definition, which you will find in the commentary on the additional protocol 1, which I will later discuss with you, we'll see that the definition of international humanitarian law basically refers to a whole of the international convention or customary rules. So so the term IHL refers to any international convention or customary rules. So basically both treaty and case law, as we said, which are specifically intended to regulate humanitarian problems. Again, it regulates humanitarian problems arising directly from both international and non-international armed conflicts. And here we can figure out that armed conflicts basically are two, as I said earlier, IX and NIX. and which restrict for humanitarian reasons the rights of parties to conflict, use means and methods of warfare. So basically, this is what says, this is one of the essences of IHL, that it limits the rights of the participants. So if there's a military that uses armed force, it's a bit ironic to say that today because of the conflict in Gaza, but we will come to this point as well. So basically, the law, at least, it intends to limit these means and methods. So what weapon you choose, how you choose the weapon, who can you target, and etc. And tries to protect people and objects affected by the conflict. So this is the more authoritarian. The second one is also authoritative definition, which is rendered by Sassouly, Mark Sassouly, which is one of the main figures of IHL. He also gives a definition saying IHL can be defined as the branch of international law limiting the use of violence in armed conflict. So as you can see, this is more about armed conflict rather than about the humanitarian problems as the first definition. It has two goals, according to him. It spares those who do not or no longer directly participate in hostilities. So anyone who is not fighting, basically, should be spared. And second, or B, it limits the violence to the amount necessary to achieve the aim of the conflict. So basically, he says that the law tries to limit the amount of violence, and this captures more the essence of IHL, that IHL does not say that using armed force is prohibited, but it says that it should be limited to the extent necessary. So from that, we can deduce that IHL is the branch of international law specifically intended to limit the humanitarian consequences of armed conflicts by restricting the means and methods of warfare, the weapons or the tactics that the military would use to achieve the objectives of the parties. It also ensures protection and human treatment of persons who are not participating in hostilities or who are no longer participating in hostilities. Third and finally, protecting certain objects of special importance, and we will come to that also at a later stage of this presentation, that certain places such as hospitals, schools, or any civilian object such as a residential building, these are all covered by the protection of IHL. So, and that brings me to the essence of IHL, and in my opinion, if you get to understand the essence of IHL, any law or any article, would just fall into under this idea. So if you're looking at a case, real case or a mood case, once you capture this essence, you would know immediately what the law would say in this situation. So this is perhaps an important aspect to look at. A law that does not prohibit armed conflict, but regulates it. And this is referred to as the balance in IHL, balance between military necessity and humanity. I call it the equilibrium of IHL. I wrote on it also during my master's at Utrecht University. And it basically boils down to two main principles. And those should be seen as the core of IHL. Those two principles, if weighed properly, then you would have all the rules and all the principles that basically shape IHL. So military necessity is basically the parties' right. So imagine two states fighting for whatever the reason. The reasons of why a state fights is irrelevant under IHL. IHL only concerns the armed conflict itself, the war itself, not why the war itself was started. So during the armed conflict, you would have military necessity, which is the party's right to use their military, use their forces, their troops to achieve their military objective. And the permissible military objective is basically to weaken the opponent or to basically bring the other state to submission. Once that goal is achieved, the party would not have basically pragmatically would not have a reason to continue fighting. So military necessity here signifies that aspect, that each military has the right to use force against the opponent. However, humanity here signifies the exact opposite, not entirely opposite. The end of the spectrum of humanity would be not to actually use force, but still, this is tolerable in most cultures, in most religions as well, that war or armed conflict is a reality that we need to deal with and need to regulate. So humanity here signifies that that the parties should use force to the extent necessary. So they shouldn't destroy the natural environment, kill civilians, torture people, etc., etc. So there are so many rules that would fall under humanity, but basically humanity signifies that there should be humane treatment to those who fight. So you also cannot torture combatants or fighters, and also humane treatment to those who are not participating in hostilities, including their civilian objects. So this is the idea, but military necessity and humanity are not applicable principles per se, so you cannot really apply the principle of military necessity or humanity. You simply use them as a framework of balancing. And from that, we have three main principles that basically governs everything that follows. Any article, I think in codifications, there are more than 500 articles. In customary rules of IHL, there are also about 161 articles. So for all these articles, they all rely on that balance, but they rely more essentially on three principles. The first one is called the principle of distinction, and you can read on it. I left some of the articles. Perhaps later we'll share the slides with you so you can look at these articles, and I will tell you in a moment how to do that. So we have the principle of distinction, and the principle of distinction basically is the first revelation of that balance. And it says in clear lines, you have to make a distinction between combatants in an international conflict and civilians. So you can attack combatants or fighters, and you cannot attack civilians. You can attack or target military objects or objectives, but you cannot attack civilian objects. So it basically draws a line between what you can attack and what you cannot. So this is the basic idea of distinction. Of course, it has so many things to follow, but this is not the topic of today's presentation. It just gives you the general idea of what IHL is about. Then you have the principle of proportionality. This is a very important principle. It basically poses the essence of the balance I just talked about, that the attacks or the military tactics should not be excessive in relation to the military objective required. So basically, we have the notion of collateral damage, and you always hear that as pertains to civilians. So you, for example, would like to kill an ISIS figure in certain territory, but this person who has a high status, he has a leadership status, is hiding in one civilian or residential apartment building. And you would like to get that target before he flees or she flees, and you would like to attack that person at the moment. In essence, you would calculate who would be in the vicinity, the amount of objects and people who you cannot attack, and then see whether this would be excessive. So it's basically a measure. It has a lot of literature being written on it. It could be, it's a topic of books, if not volumes. So we cannot really cover it in this session. It's also not the topic, but in essence, proportionality is one of the core or cardinal principles of IHL, and basically say that attacks should not be excessive in relation to the military objective pursued by the parties to a conflict. Then we have the principle of precautions. It's basically stems from the same ideology, that when you attack, you have to take your precautions just before you attack. Make sure that you're attacking the right target, that you're not killing too many civilians or civilians at all, if possible, that you're choosing the right method. So this is basically what I referred to earlier as the idea of IHL. The idea of IHL is the equilibrium between military necessity and humanity, which is revealed in three main principles: distinction, proportionality, and precautions. Okay, so far so good. So when we refer to IHL, we need to know where IHL stands in international law. And the first thing is to refer to public international law, which I hope all of you are aware about or have studied it. And basically, IHL is a branch of that law, public international law. And public international law is the law that governs the relations between states. You will see it in treaties, you will see it in conventions. If you look at the UN, anything that has to do with that is public international law. And public here, of course, signifies that it has to do with states or the public, the public aspect of things versus, of course, private international law, which has to do more with contracts and agreements, bilateral agreements, and lesser situations that do not necessarily deal with public international law or states in general. So public international law is the main governing or the main legal regime from which there is a branch. One of them is IHL, and that means that IHL is informed by public international law. So, for example, the sources of IHL would follow the same structure of public international law, which can be found in Article 38 of the Statute of the ICJ. But also when IHL, the norms of IHL would contradict with norms of other domains, such as human rights, then you would find principles of public international law, such as principle of lex specialis, would really govern the relationship between IHL and other norms. So, and in short, IHL is a branch of public international law and is bound by what public international law would say about general things: sovereignty, self-determination, human rights, all of that. Okay, so this is the most important distinction. And again, I am covering this as fast as possible. I am aware that some of you also have attended a lecture by the ICRC, which would definitely touch upon all these things. But this is, we have to go through this to know where IHL stands and pinpoint the sources of IHL. So you as motors would be able to navigate these laws as professionals. So the second legal regime I would like to bring attention to would be the law on the use of force, or jus ad bellum. You'll always hear jus in bello versus jus ad bellum. And this is essentially the law that governs the conduct, not the conduct of armed conflicts, but the legality of armed conflict. Whether the war that my country is now waging is legal or illegal. And it boils down to the principle of self-defense. But the main thing to say here is that this is a separate part of legal regime. Of course, there are debates about that. Some authors or some experts would argue that both laws are connected, that whether the armed conflict itself is legal or illegal would affect the framework of IHL, but the position of the ICRC and most IHL experts would say no, they are not connected, because if you connect them, you would basically perhaps dilute the principles and rules of IHL. Because if you say my opponent is already waging an illegal war, I will not respect the Geneva Conventions, I will not respect IHL, then that wouldn't put us in a situation where we organize armed conflicts, really. So we also have the law of neutrality. I wouldn't also talk much about that, but basically it's a complementary law. Like if we make a fair comparison or a quick comparison, it would be that IHL basically regulates the relation between the belligerents or the parties to a conflict, while the law of neutrality regulates the relation between the belligerents and the neutral parties, third parties to the armed conflict. So they basically complement one another, but many people or many scholars of international law would believe that the law of neutrality is part of IHL, or actually the other way around. It doesn't matter, but in my view, both are separate entities because they have different objectives. We also have international human rights law, which is a body of law that, as I would say, applies anywhere and everywhere. And applies always. So the fact that there is an armed conflict, as we will explain when and how, does not say that IHL, human rights law does not apply. So armed conflict happens, still human rights law applies, and the relation between human rights law and humanitarian law has been dealt with in many regional case law, which could be also covered in a different session. But what is important here to say is that human rights law continues to apply, and hand in hand with IHL, and both can be interpreted to complement one another, because in some situations one would trump the other, because a belligerent party or a soldier basically can kill another soldier, while human rights law, Article 1, the right to life, would say, no, you cannot kill a human being, you cannot take a life. So in some ways, there would be a conflict, and this would mainly be covered by the principle of lex specialis, which would say the most applicable or specialized regime. Just to bring your attention to the general lines of what or how IHL can interact with human rights law. We also have international criminal law, which I believe some of you will have questions about. It's basically also a different body of law, which basically is more about, not about states. So states would sign their own statute to be part of the jurisdiction or the regime of international criminal law, governed by or applied mainly by the International Criminal Court. But eventually, criminal responsibility or international criminal law would apply to individuals. We call them the big fish, so officials and leaders. And basically, if we look at Article 8 or look at that body of law, we would find that it also regulates what we call war crimes, and war crimes are violations of the Geneva Conventions or some of the articles of the Geneva Conventions. And here it suffices to say that, that international criminal law basically ensures compliance with IHL, because it lays criminal responsibility to those who violate IHL. Okay, we also have the law of occupation, and the law of occupation is basically part or a branch of IHL. So it's not a separate law, it's part of IHL. I will not say more about the law of occupation because we will come to it in the next slides. So the legal sources. So now you are having a moot court case or real case, and you have a set of facts before you. You want to deal with these facts. You want to analyze these facts. You want to see them from the perspective of the law. And you are committed to do that from the perspective of IHL, because likely there is an armed conflict that took place, and IHL then is applicable, and you want to navigate the rules. So like we do with our domestic law or other international laws, there is a priority or what we call it authority of legal sources. So we would rather use the most authoritative or the most persuasive legal text or cases or declarations that come in handy when you make an argument. So we would like to do that the best or the most persuasive way. And of course, the same would follow, that we have primary sources and secondary sources, which is also reflected in the Article 8 of the ICJ statute. For IHL, we have the Geneva Conventions. These are basically the Bible or the Quran of this regime. The Geneva Conventions were codified in 1949. Of course, before that, there were other laws, especially the Hague regulations, and all these rules basically regulate so many aspects of the conduct of armed conflict. We also have additional protocols 1 and 2, which were codified in 1977. These are all we can refer to as treaty law, and those will have the most authoritative power, so to say. So when you make an argument and you would like to substantiate to that argument, you would most definitely need to see whether treaty law supports what you're saying or not. And then we also, in order to understand the treaty law, we would need to perhaps sometimes when the situation is really fuzzy, when the set of facts is new, and perhaps you didn't really find that meaning being exactly written in one of the articles that you think is relevant, then you can go to the preparatory works and the commentaries that are on that article, much like with any legal regime. Also, what is extremely important in the domain of IHL is international customary law. We call it customary IHL, and it's basically like the rules of public international law. It's a general practice of states or organizations that was accepted or has been accepted as law. It's binding. It feels binding. So for states or for anyone to objectively pinpoint whether there is a custom here that regulates a certain situation, you go to state practice and opinion jurors. And I left here some examples on the slide so that you can think along with me of what could constitute state practice, especially in the domain of IHL, and what constitute opinion jurors. So the acts and official positions of states, their declarations, their military manual. Each state, of course, will have a military manual. Most of the time, I think every state, if you look for Egypt, Jordan, any other state, you would find manuals. Some manuals are more extensive and more developed, such as the US manual. You can check these manuals and read it for yourself. You will find the practice of these states and what they deem binding. You also see bilateral treaties, domestic law. So if there's a domestic rule in Egypt that forbids a certain act, that could be taken as a state practice and opinion jurors as well. Unilateral declarations and resolutions of international organizations. We have the ICRC customer study, which I will explain in a little bit. This basically has everything. So it's the ICRC put together, and probably you've also heard about this if you've attended the session by the ICRC. The ICRC put together all the state practice and opinion jurors together in one study and came out with 161 rules of customary law, and it has been deemed as authoritative rules, and everyone follows them. And if you look at these rules, you will find why each rule has become or is suggested to be a customary norm of IHL. In that sense, you will find all these things that I mentioned, the declarations, the military manuals. The study really cites all these, documents and makes persuasive arguments on what should be deemed as customary IHL. It's really helpful, so I will tell you how to deal with that. Of course, we also have general principles of law. This is basically mirroring the ICJ statutes, Article 38. And also we have subsidiary means, judicial decisions, case law, which is important in that field as well, as I will come to share with you, and legal doctrine. So people who publish articles and in peer-reviewed journals who write about IHL and analyze situations of armed conflict, these could also be taken as authority in that domain of law. Okay, so treaty law. And treaty law, basically, I would invite every one of you to spend perhaps 15 minutes, 20 minutes today, perhaps every day until the end of the moot court. Perhaps you've already done so. So this might be familiar to many of you, that the IHL database, the ICRC has a huge and very useful database, which you need to navigate and understand. Go left and right and see how they organize it. And if you see, I selected here treaties. And if you go to treaties, you will find more than 60 international humanitarian law treaties. So you can rely on those. Some of them would be relevant. You would know from the title whether it's relevant. So if you're looking at a specific weapon, as presented by the case facts in mooting or in real life, you would just simply need to read more and more, be aware, be familiar basically with treaty law and the existing treaties. And of course, following the logic of the equilibrium of IHL, you would know whether IHL organizes something like that. So you would know whether there is law simply by knowing the ideology of IHL. And the customary law, as I said a minute ago, there is a customer study that was initiated in 1995, and the ICRC carried this study with people who are known in the field and with teams and in collaboration with many governments, and they came up with that volume here, some of it, and also if you go to the database, you can simply click the customer IHL in blue, as you see it also in the pictures. And it has 5,000 pages, so it's huge. And it defines the domains of IHL. So each of those could basically be the topic of lectures, if not series of lectures. So we could see the principle of distinction being one of these topics. Then especially protected persons and objects, such as cultural heritage. Specific methods of warfare, you could see siege, occupation, and then we see weapons here, which would be all types of weapons that could or could not be used. Some are forbidden, such as chemical weapons, and some are not. Then the treatment of civilians and persons hors de combat, people who got injured during the fighting, and implementation of IHL. So you can basically navigate these rules, read along, and you will find again that 159 of these rules, and I left some links below. So if you later look at my notes on this slide, you will see that basically the rules almost apply to both international armed conflict and non-international armed conflict. So 159 rule apply to IACS, and 139 apply to NIACS. So basically, it's pretty much the same from a customary point of view. The rules of IACS are more or less the same as NIACS. Okay, we also have the Martin's clause. I'm not going to go in detail, but this basically clause or article adheres to more like natural law kind of mentality. So it's a catch-all article. So in case there is a new weapon, such as the new weapons that are now being discussed, such as autonomous weapon, lethal autonomous weapon systems, cyber attacks, all these rules that have not been covered in Geneva Conventions, in treaty law, nor in custom, because they are quite new and we don't really know how to deal with them, then you would then apply the three principles we talked about: distinction, proportionality, and precautions, and try to assess whether these weapons can work objectively, legal or not legal. But then we have the Martin's clause, which basically all the experts would use as a framework to say whether a specific weapon or method is adheres to the principles of the law of nations, and whether it adheres to the laws of humanity and the dictates of public conscience. Okay. Before I move on from sources of IHL, I would like to bring this because somebody is okay. So before I move on to conflict classification, which is the essence of this session, I would like to draw your attention to these three types of law, which is basically not relevant today as much, but you might hear them every now and then. We have the law of Geneva, which is the law of protected persons, which basically pertains to Geneva Conventions. We also have the law of The Hague, which relates to the earlier regulations and rules that basically relate to limiting the methods and means of warfare for the warring parties. And the third one would be the law of New York, which mainly relate to United Nations peacekeeping operations, would relate to human rights during armed conflict, would relate to arms control. So whether or to what extent can you export a specific weapon or weapons to a state that is violating international law, and to what extent you would be involved, all these questions would be addressed. So you could find these three distinctions, or mainly the first two distinctions, the law of Geneva or the law of The Hague. But I would like to let you know that it could be used as an indicative kind of terminology or names, but they are merely historical and didactic value. They have that value because in 1977, when Additional Protocol 1 and 2 were codified, then other matters that was preserved to the Hague Law became discussed in Geneva as well. So it's no longer as relevant, but you would find it mentioned in many of the literature. Don't get confused by it. Okay, so more to the real stuff, I would say. Today we will discuss only the things that I marked in bold: applicability, ratione materiae, which is the material scope of application. Basically, what does IHL regulate? So the things that IHL regulate. What does IHL regulate? Which is, of course, armed conflict. But we need to understand what armed conflict means. And I will leave the ratione temporae, which is when an armed conflict exists and when it ends, because it has less relevant for your case, but it also has less debatable. You can read on it more and more. Same for the geographical. And I will then also look at to whom does IHL apply, which is the ratione personae, which is the personal scope of application. And in IHL, it's a bit different. We have active personal scope and passive personal scope. People who are bound by IHL and people who are protected by IHL. Okay. We go to armed conflicts, and if we look at the Geneva Conventions and additional protocols, so the treaty law. So now I will refer to what I just shared with you about the sources of IHL. If we go to the treaty law, the most authoritative part, we would not find, unfortunately, a clear definition of what armed conflict is. But if we go to the famous Tadic case of 1995, we'd find a definition that has been followed since then by courts, by laws, and by everyone. So they are taken as customary, they are taken as most authoritative, even though they are not treaty law. And in Tadic case, by the International Court of the former Yugoslavia, we will, a tribunal for the former Yugoslavia will find that the court said that armed conflict exists whenever there is a resort to armed force. So we have to have an armed force between states. So that's the first one. There is an armed conflict or armed force between states, or protracted armed violence between governmental authorities and organized groups, or between such groups within a state. So from that, we can deduce that there are two types of armed conflict, and this has been the case. Some other people or scholars argued that there are more types of armed conflict, but as of now, contemporarily, there are only two types of armed conflict: the one that is between states, and the other which is between the state, an armed group, or two armed groups within a state. We also find that the definition of armed conflict is a factual one. So basically, you need to look at the facts and determine whether there are two states fighting one another, or there are a state that is fighting an armed group. And basically, you would come to the conclusion whether there is an armed conflict that exists. And then we also deduce from that the application of IHL, because once you define that there is an armed conflict, once you determine that, factually speaking, that there is an armed conflict, then that essentially means, or mainly means, that the rules of IHL would apply, would bind those parties who are fighting one another, and would protect those who are in the fog of war. So the third thing we can come up with here, or deduce from the second point, would be that deciding whether there is an armed conflict is basically a factual matter, which also means that it does not depend on political or legal declarations by states. So a state could say, I'm not in an armed conflict right now, I'm not fighting, but basically IHL would still apply to that state, would still bind it, because it's not a matter of who can decide that, but usually you would have more courts being involved. You would have the United Nations being involved in that, and the recognition of states could play a certain role here. But yeah, it's essentially a factual determination. Once there is a situation of armed conflict, as we will come to explain how exactly, then IHL would be binding, and anyone who violates IHL would be perhaps committing breaches of that law and committing war crimes. So let's look at the first one, a resort to armed force between states. And that basically reflects the IACS, or the International Armed Conflict, as we said. And that is basically referred to as regular interstate armed conflict. And this you will find, and I would ask you to go to Common Article 2 of the Geneva Conventions. Common Article means that it is an article that you will find in the 4 Geneva Conventions. So if you open Article 2 in any of these conventions, you will find that article. And basically, it defines, or it is used as the treaty law that defines armed conflict. And here you would see that it's saying all cases of declared war or of any other armed conflict which may arise between 2 or more states, even if the state of war is not recognized by one of them. So you'll find this matching with what the judges said in the Tadic case, essentially. And then we see that it adds another regular interstate armed conflict, which is the convention shall also apply to cases of partial or total occupation of the territory of a state. So occupation, which means the effective control, according to Article 42 of the Hague Conventions, the occupation or the effective control of another territory by a foreign state, that would constitute an occupation, a situation of occupation. And a situation of occupation, according to Common Article 2, that would qualify as an international armed conflict. We also have wars of national liberation, and this is quite the innovation because this also more or less relates to occupation, but in a different manner. So if you look at the definition, or how Article 1, Paragraph 4 refers to it, we'll see that armed conflicts in which peoples. So here we have a new term, peoples, and this is basically what, or big chunk of my PhD is all about, because I also look at situations of occupation in general, and in particular the situation of Western Sahara, which is in North Africa. Perhaps we can talk about it in a different timing, but for now, it suffices to say that international law recognizes peoples as sovereign entities. So it's a group of people or a population who reside on a specific territory who cannot really govern themselves for whatever reason. And the main reason for that was the era of decolonization and what happened at that time. Some states or some territories remain as non-self-governing, or some peoples then would still be owed the right to self-determination, the right to choose to be part of another state or to establish their own independent state. So until those peoples establish their own state, they will refer to as peoples under international law. And here, what I want to really say is that the occupation of a state, as enumerated in Common Article 2, is the same as occupation of peoples. So let's read the article one more time. Armed conflicts in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. So basically, people who have the right to self-determination, and this also, to some extent, applies to the people of Palestine at the moment. Many states now recognize Palestine as a state, but if it's not a state, then still it is a territory of a people, which is captured by Article 1.4, as we will come to analyze in more accurate terms. So, international armed conflict is basically an armed conflict that can take many shapes. The main one of which is the regular interstate armed conflict, state and a state, or states and a state, states versus states. It could happen perhaps in space. So you have Egypt fighting, I don't know, any other country, Germany, for example, and both they are having their ships in the high seas, so basically not in any territory, and this used to be the form. So countries or nations would be fighting in an empty area, in a desert, in the space, anywhere, or maybe they would be fighting in one of the territories of either state. So the US would go to invade Iraq or fight Iraq in the territory of Iraq. That could also be looked at a situation of international conflict. It boils down to two states or number of states fighting one another. And this is captured by the first picture here. You will have the armed forces of state A fighting the armed forces of state B in a neutral area. Or state A, I don't know where the armed forces of state A have gone, but the armed forces of state A would be fighting in the territory of state B, fighting the armed forces of state B. But we also have belligerent occupation, because the term occupation is quite a terminology actually in international law, and the one that relates to IHL would refer to as belligerent occupation. And we have to remember that occupation or situation of occupation is not an illegal situation per se. So according to international law, occupation could be legal or illegal. So if we talk about IHL, if we want to classify a situation, see whether there is an international armed conflict, it is a factual determination. We simply want to know whether there is an international armed conflict there, or whether there is an occupation there, same thing. And we want to look at the facts. But the conclusion of that determination or that assessment would not say this is occupation, therefore illegal or legal. The only conclusion that you can make is that IHL, or the law of armed conflict that applies to international armed conflicts, would apply in this situation. And this is really captured by belligerent occupation. So if a state is an occupying power, as referred to under IHL, conducting a belligerent occupation, that state is bound by IHL. But there's nothing that says anything about the legality or illegality of that occupation. So we see belligerent occupation of a state or a people, and this is captured by both articles. So even Common Article A captures both scenarios, whether there is an occupation of a state or a people, because the word state here, if you go to the commentary on Common Article A, you will see that the commentary says that the terminology state here can also or does in fact include a people, a reference to a people. So it doesn't really matter under Article 2 or under Article 1.4, state of occupation can happen against or of a state or a people. And basically, when we talk about occupation, the determining factor here is effective control. So whether we have a foreign entity, a state, that is effectively controlling a territory of people or a state. So basically effectively controlling that territory. And effectively controlling a territory means that you have power over that territory, whether by force, by military, or any other way, but you can control it. You can say what happens in that territory. And of course, it has a lot of discussions. I find it particularly interesting. So we have state A that is using its armed forces, that goes to state B, and I draw these dotted lines to signify that this part is effectively controlled by the armed forces of state A. We can also have state A going to the territory of state or another territory of a people, and here we find National Liberation Forces would be fighting against the armed forces of state A. And even if there is no resistance by the National Liberation Forces, that still qualifies as an occupation. So that's generally referred to as belligerent occupation or bloodless occupation. Let's move a little bit faster, so not to run out of time. And Abdurrahman, please remind me when I have 15 minutes to go, so I can manage my time a little better, because I cannot see anything once I put that screen on my monitor.
Walid, I believe you have, I think, 10 minutes from now.
10 minutes. Okay.
Yeah.
I kind of sensed it. So we're actually coming to a close in a moment. So 10 minutes would be good. And if I spill over for 5 minutes, I hope you would forgive me today. So to sum it up, the material scope of application of international humanitarian law in the situation in IAC, so international armed conflict, would require an armed force. That armed force could be a declaration of war, so a state says, I'm going to attack the other state, or what is often referred to as the first shot. So you imagine a soldier standing on that territory and then shooting the territory of, shooting another troop from the opposing state. In IHL, that would qualify as an armed conflict. From that point, an armed conflict or an international armed conflict would start. And then, of course, a bloodless occupation, because occupation per se uses force. So even if the people, the occupied people, could not resist that occupation, that would still qualify as an occupation, because in essence, occupation relies on force. And we would see also another facet that this happens between two or more states or people. And these basically are the main facets here. And then the applicable law would be the Hague Regulations of 1907, but also the Geneva Conventions, all the Geneva Conventions, the 4 of them, and additional Protocol 1, except for Common Article 3, which applies to non-international armed conflicts, as we will start in the next slide. So we see that Geneva Conventions apply. So if you decided that the situation in front of you is an international conflict, these are the applicable laws. These are the main applicable laws: the Hague Regulations, Geneva Conventions, and additional Protocol 1. And we might, in certain situations, have to visit the occupation law, which is basically part of Geneva Conventions and customary IHL. And the third one would be customary IHL as well. And that would be 159 rules out of the 160 rules. And I left sources of which of the rules apply to international armed conflict. Okay, they covered most of the things. Now let's go to the more entertaining and the more, I wouldn't use entertaining here, but I would say the more difficult, the more challenging, and the novel aspect of IHL. If we look at Common Article 3 of the 4 Geneva Conventions, we would find a definition, a negative definition of non-international armed conflict. And it goes as follows: armed conflicts not of an international character. So any armed conflict that is not international. So the first thing that comes to your mind is that we are not going to talk about states fighting one another anymore. Occurring in the territory of one of the high contracting parties. High contracting parties are basically states, or also peoples, or whoever. If we look at the case law, starting from Tadic of 1955, Dinesh, Buskowski, and other cases of the ICC, we will find that this definition is also taken, protracted armed violence between governmental authorities and organized groups, or between such groups within a state. So we see 2 criteria popping up. One is the protractedness, and that basically entails that we have a state and an armed group, and there is intense armed violence going on. It's not a riot, it's not a simple internal disturbance that is going on that the state would address, but it's more. It's a non-international armed conflict because it is intense. We also look at the group itself. So the group itself looks like a structured group, like an organized group that has a commanding officer, that has strategies, that acquires weapons, and as I will say more in the next slide. So non-international armed conflicts would be, or NAC would be those armed conflicts that are not international and that happen between or take place between a state and an armed group, or an armed group and another, or several actually. We also see additional Protocol 2, which mainly applies only to non-international armed conflicts, adding, defining here, or Article 1.2 defining what is not covered, because we now have three layers. We have international armed conflict, we have non-international armed conflict, but we also have less intense violent acts, and this is captured by Article 1, Paragraph 2 of Additional Protocol 2, which says that this that armed conflict basically does not include internal disturbances. These could be riots, isolated and sporadic acts of violence. Okay, so if we look at the case law that I just referred to, we will find that the word intensity and the word organization have been both accurately defined by some of the elements, and these elements shouldn't be, they are basically not cumulative, so some of which could amount to intensity. So you can argue either way. If you want to talk about intensity, you would refer to the number of confrontations, the number of individuals being involved, the weapons, the military, there were tanks, other things that were used, military force, and other things such as the casualties, how many people died, both from the military and the civilians, and whether the United Nations Security Council is involved could also be an indicator that there is an armed conflict or there is an intense aspect of this conflict. Then we look at the organization, and here we could look at other indicators such as that there is an armed group that has a commanding structure. So we know that there are leader figures. There's a place somewhere that constitutes the headquarters. Perhaps that this armed group is controlling certain territory. The group can plan, can do tactics, can negotiate, can conclude agreements and ceasefires. So basically, this is NAC, and we have also Additional Protocol 2, and I would like to make a quick note about Additional Protocol 2. Additional Protocol 2 applies only if the Article 1, Paragraph 1 standards are met. So it doesn't really reflect non-international armed conflicts. It adds a little bit more rules, about 28 rules. And for that to happen, the threshold that we just talked about has to be met. But also we have two other additional requirements. One, that the armed group has a certain territorial control over a specific area. So that is now a requirement, not an indication. And that group also has to have the ability to implement Additional Protocol 2. So if those two additional criteria are met, Additional Protocol 2 can also be relied on in a situation of non-international armed conflict. Okay, so here I make some reflections on how those two articles relate to one another. Just to make a brief reminder, when we talk about international armed conflict, we talk about Common Article 2. And when we talk about non-international armed conflict, we talk about Common Article 3. Both are in Geneva Conventions, the four of them. So when we here talk about Common Article 3, which is the main article for non-international armed conflict, we talk about it as the one legal source, one main legal source, aided by the case law. And if we would like to add the more rules of Additional Protocol 2, the threshold that I just mentioned has to be met for that legal text to apply. So the material scope of application here, basically to make a quick sum up to non-international armed conflict, we would require a protracted armed violence. We just said what is protracted, which entails a certain level of intensity, and it has to involve organized armed groups with a certain level of command structure or organization. Here then the applicable law would be Common Article 3, which we use to classify the situation as a non-international conflict, and we would rely on customary IHL. And here's customary IHL is quite important because, as you could imagine, the Geneva Conventions are all meant to organize IACs, international armed conflicts, and only Common Article 3 organizes NICs. So in that sense, customary IHL, which codifies a lot of rules, is more on use for non-international conflicts. This is perhaps for next time. Okay, I promised to talk about this, so I'm gonna give it another minute if Abdurrahman does not pop up and tell me, Walid, your time is up.
Yeah, of course, sure.
Yeah, okay, so who's basically bound by, who's protected first by IHL, and who is bound by IHL? So in international armed conflicts, we'd find that the wounded, the sick, the shipwrecked, the medical personnel, religious personnel, and prisoners of war, civilian population, civilian objects, all those are protected by IHL in an international armed conflict. And then if we go to non-international conflict, we will also find the civilians are protected and any member of the armed forces. But we gotta know something important here about the status of those people or those objects between IAC and NAC. So in IACs, we would refer to fighters as combatants. So only troops who are acting on behalf of a state, so official, formal soldier or a private or a leader, that would be called a combatant. But in a non-international armed conflict, if we talk about organized armed groups, we don't give them that status of combatant. We refer to them as fighters. Also, in non-international armed conflict, we find that term, I wrote it here, DPH, which is civilians who are directly participating in hostilities, and those are civilians who are mere civilians, but at a certain point in time, they started taking part in the hostilities. They carried arms and started killing, or they perhaps captured a prisoner of war or somebody and then attacked them or tortured them. So they would come with certain nexus to the armed conflict, and then they would, as long as those civilians are participating in hostilities, they would be considered as fighters. So these are the basic things that we can differentiate, and I invite you to read more on it. But also, there are also certain protections that apply to both IAC and NAC, and this is the most important of which is the ICRC convoys and relief personnel, but also the specially protected objects such as the cultural heritage objects. And the last thing that I would like to also mention is the natural environment, which has to be protected in both armed conflicts, either NAC or IAC. So who is bound by IHL during an armed conflict? That would be states, also international organizations. So the United Nations, if it's sending a peace operation, peacekeeping operation, this personnel would also be bound by IHL, which means that they have to make a distinction between civilians and combatants in IAC, or fighters and civilians in non-international conflicts. And also take precautions and attack do not excessively attack civilians. We see also that other non-state parties to conflicts, such as the armed groups, those are also bound by IHL. Individuals who have nexus, such as those I referred to earlier, anyone basically who fights or interacts with protected persons. So if you're come in contact with anyone who is, so perhaps you're in a different state and you captured someone who's fighting, or you conducted certain attacks, perhaps cyber attacks from abroad, then you would be captured by IHL and you would be bound by IHL. So in summary, armed conflicts do not take place in a vacuum. Once there is a situation of an armed conflict, there will be certain rules that apply. And these are the rules of armed conflict or international law. We have two bodies of law, one that applies for international armed conflicts and one that applies to non-international armed conflicts. And the main idea is that we protect human life and dignity. So we also talked about who are the parties of the armed conflict, and those for international armed conflicts, those would be states, but for NACs, those would be states or organized armed groups. And we have a very interesting thing that I did not talk about today, but perhaps we will talk about in the context of the next lecture, which would be states versus organized armed groups in a different state. So we have a state that is fighting an organized group in a territory of another state or a territory of a people. So this really perhaps touches upon the situation in Gaza, and there are some debates at the moment whether the situation in Gaza qualifies as a non-international conflict, because it's basically the state of Israel or the regime of Israel or whatever it's called, fighting against the Hamas, which is an armed group located in a territory of a people or a territory of the state of Palestine. And therefore, it is qualified as a non-international conflict, while others would oppose or uphold the position that this is a situation of occupation, whereby Israel effectively controls the territory of Gaza. And then again, they say that Israel ceased to occupy Gaza since 2014. And then on the 7th of October, 2023, that was not a situation of occupation anymore. And that Israel was basically attacking an armed group in a different territory. So in this sense, the majority of voices, and I believe also the prosecutor of the ICC, would take the position that this is a non-international armed conflict, but not without debate, not without criticism, because this could also somehow undermines the international armed conflict or the rules that apply in international armed conflicts, which are exactly enumerated in treaty law of IHL. I think that's it, Abdurrahman. I hope I've covered the topic to your understanding. There's a lot of literature that you can read. I also left some slides for you to look at. And while we have this session of Q&As, we can also look at these remaining slides together for your later purposes.
Thank you, Walid, very much. It was such a session, short but full of information, informative, and truly interesting. I think we do all have a common understanding that the subject of this session is broad, and as you just said, was tackled in extensive literature. So as for a 1-hour session, that has perfectly done the job. So thank you very much for showing up today and for the presentation and the content, of course. I can see that we don't have many questions so far. Well, Fatim has contributed with one. I'm a bit confused on the difference between IAC and NIAC and occupation. So these are three, I think, variables, three elements.
What the question is again? The difference between IAC, NIAC, and occupation.
IAC and the law of occupation, I guess, and whether they are subject to the same rules of international humanitarian law or not.
Of course. So as I just tried to demonstrate, occupation is a factual situation. It's nothing has to do with the legality of that situation. It's once there is a foreign state or entity that occupies another territory, we are about a situation of occupation. And a situation of occupation, according to IHL, is a situation of international armed conflict. So if we talk about occupation, we talk about international armed conflict. It can be seen as synonyms. And the law of occupation is basically part of the law that applies to international armed conflict. And you will find that body of law, body of rules within the Geneva Conventions. And as to the second part of your question, whether the same rules applies or which rules applies, of course, if we have a situation of occupation, that situation is an international armed conflict, and then the rules that apply to international armed conflict would apply, as opposed to the rules of non-international armed conflict. But then again, I will refer to the customary IHL, which is the study that was conducted by the ICRC, which holds a high authoritative value. That study concluded 161, which I would really urge you to immediately, upon this session, take a look. There's also an application. There are many ways. You will find it really smooth and really accessible. look at these 161 rules. Perhaps you can read them after the feast, of course, not during the feast. I am aware of the fasting and all of that, but take a look at them and you will see that the rules that apply in IHL are more or less the same everywhere. Perhaps for the connotations, who you can call combatants, who you cannot call combatants, and other terminology. And this actually is a third voice. So if you heard me at the last slide, I said that there are scholars who argue that this is an IAC, the situation in Gaza, and others who argue that it is an IAC. There is a third position which says, okay, it doesn't really matter whether it's IAC or NAC, IHL will apply the same. So it doesn't really have a significant value. But then again, it has a significant value because any armed conflict would have to fit in any of those classifications. However, IHL would more or less apply the same way in either situations. That would suffice. And if you have more questions or if you did not catch the meaning, let me know.
I think the questions are kind of raining on now.
Okay, I see, yeah.
But due to the time restraint, I think we'll be limited. So we'll pick a couple of questions and then perhaps postpone the rest of them until next time or receive them by email if you want.
Yeah, of course.
From Hagar Yahya. I think you've partially answered this. She's asking whether, aside from the situation in Gaza, whether it's NIAC or IAC, doesn't a state or an entity, to leave you some room to decide, an entity would enjoy the right of self-determination either way?
Regardless of the situation in Gaza being classified as an IAC or NIAC, doesn't the right to self-determination? Yes, it applies. So the right to self-determination, basically, you can find it codified in the Charter of the United Nations, Article 1, Paragraph 2, and basically it is a human right. It is an international principle of just cautions status and erga omnes status. So it's really one of the international legal norms that uphold high status, and it basically entails that a people of a territory. By the way, the right to self-determination has two aspects, one internal and one external. So if we remember the situation in Spain where the Catalonians wanted to split, this would be an internal right to self-determination. It's a people within a people who would like to split, but the right to self-determination we talk about is the external one, and that really holds a greater status, and it should be protected at all times, and it cannot basically be overruled. So if another state would occupy another state and create settlements, annexes this territory, tries all of its best to occupy that territory and take it, such as the situation in Israel and Palestine, that right to self-determination would never be affected. It would remain the same. It would remain the right of the people to establish their own independent state. So until that time, until they decide on their independent state or they decide to join another already existing state, until that time, they would have the right to self-determination, which has so many revelations and has so many grounding in international law, not only in the Charter, but also the Declaration on Decolonization. So yes, to answer your question short, the right to self-determination applies in either way, but the reason why I mentioned it today is to say that a people who have the right to self-determination would be captured as a state, which in the sense of classification of international armed conflict. That's it.
Well, great. Well, another question is about the threshold, I guess, the threshold of occupation. How do you decide when a state of occupation starts?
Yeah, I see. So when a situation of occupation starts. So this is more of a. I'd like to understand the question a little bit more thoroughly. Can you reiterate, Abdurrahman?
Yes, Ahmed Ali is asking, how is the status of occupation decided? Is there certain criteria for a territory to be considered occupied or not? So it's
Yeah,
basically
that's
like the threshold, and whether there is effective control or not.
yeah, exactly. So this is the status of occupation is decided when there is and here we talk about belligerent occupation. That status is decided by referring to Article 42, which basically says a territory is occupied when it is effectively controlled by a foreign entity. And basically that's a threshold. There's a threshold of consent. There's so many other criteria that you can look into, but that would be a topic of a sheer discussions. But it suffices to say that occupation, or for the purposes of this session, occupation is classified as an international armed conflict. That's what we need to know at this stage.
Palisa, if excuse my pronunciation if it's not correct, is asking whether the second additional protocol applies to IAC or not.
Additional Protocol 2 applies to NIAC, and as I said, Additional Protocol 2 basically has two paragraphs, paragraph 1 and paragraph 2. Paragraph 1 has certain criteria. If are met, then the Additional Protocol 2 would apply. And paragraph 2 basically pertains to what is not a non-international armed conflict. It basically says that flights and internal disturbances, anything that is not of an intense level, that is discarded. So we have two paragraphs. So if the requirements of Article 1, Paragraph 1 are met, all of them, then Additional Protocol 2 would apply. And it cannot be imagined that Additional Protocol 2 would apply to anything but NIAC, non-international armed conflict. However, the distinction that I tried to make today is that Additional Protocol 2 does not represent NIAC, does not represent, it's not a legal document that says we have to meet all these criteria for a situation of NIAC to take place. It merely says that if these additional criteria are met, then those additional 28 articles would be applied. However, Article 1, Paragraph 2 basically applies to all NIAC. I hope that is not, I hope people are not confused at this stage.
I think it's quite clear at this point, yes.
Okay, good.
Another question. Another question from Farida is, she's asking, what if one of the states within a conflict doesn't recognize any or one of the binding sources? Would they still be applied upon them or not?
The answer is yes. Yeah, the answer is yes. So it's the qualification of armed conflict is a factual determination, regardless of any legal declarations made by states or political declarations. They will be bound by it. And there are, of course, we do not discuss the mechanisms by which states or individuals would pursue justice for the violation of these norms. But in principle, a state would have to be applied by the law, even if it says it doesn't apply to me.
Well, fair enough. And that, of course, extends to the case of not recognizing that source of law. I think that's hard to imagine, of course, in a case of Geneva Conventions, because there is international consensus on them. No one can say that. The Geneva Conventions are basically universally applied. So I believe 193 or 194 countries out of perhaps 195. The UN states. So it's universally applicable. As for Additional Protocol 1 and 2, they are not the same. They have less application, but they codify customer HL. So in principle, people are bound by them, unless it's of course a discussion in public international law. If a state is objectively or persistently objecting against a specific rule and has been consistently doing so for years, so before that norm has become a binding one, that specific state or specific states persistently objected that rule, then it doesn't apply to it as a matter of international law. I guess the question then boils down to what if a state contests whether a rule is part of customary international material law or not, whether customary international law, the conditions of customary international law are applicable to a certain rule. or not, and that has to be a factual question, a case-by-case question.
You mean about customer international law?
Yeah, I think that what it really boils down to, what it really comes down to.
Yeah, I believe so. But as I said, if we look at if we're talking about the customer rules that have been provided by the ICRC, which the states in their conferences, in their application, in their practice, have confirmed that they represent customer international law, then it's a bit debatable. So you'd have to come up with serious legal arguments to say otherwise. So you would have to rely on case law. You would have to rely on other treaties to say that this norm does not reflect customer international law. So yes, it says objective determination indeed.
Fair enough. One last question, very brief answer. Ali is asking whether there is limitations, whether there are limitations to the applicability of the additional protocols or not.
There are indeed, that's excellent question. There are indeed limitations, and I could simply draw. So I talked extensively today about additional protocol 2 and how it is limited substantively because it puts really high standards, and these standards do not really apply to any conflict because not any armed group can implement additional protocol 2. So we're talking about a really armed group that has an extreme level of organization, extreme level of intelligence. They basically are people who can understand what we're talking about right now. So this is the level that additional protocol 2 would imagine. So I wouldn't talk about that objective aspect, but there are other limitations, and I would invite you to look at these. And that limitation would be membership. So whether a state have ratified the additional protocol or not, that would determine whether the additional protocol would apply for it or not. As an additional protocol, but again, as I said, some of these rules or many of these rules in the additional protocols reflect customary IHL. So if you would like to make an argument, you would better rely on customary international law, unless, of course, the states that you're talking about have adhered or have signed the additional protocols, then you would have a higher status authority, which is treaty law, that you can rely on. That's my answer.
Okay, perfect. I think now we've wrapped up everything. And that brings us to an end for this session. Well, let me clarify a few things in relation to the organization and the competition itself. First of all, thank you, Walid, for, again, such an informative and interesting session. We've really enjoyed the past hour and a half. The questions, the session and the explanation have actually triggered some interesting questions as well. Luckily, we'll be having Walid next week to proceed to the most related and the most interesting session about the methods of warfare, particularly the use of information and cyber attacks, which is directly an issue directly related to our mooting case.
Yes.
Again, thank you, Walid. As for the competition itself, I believe that all the non-Egyptian teams will be receiving the invitation very soon, I think within these 2 days, and that should be used to produce your visas. I encourage all of you to start the travel process as soon as possible. I think we will also hear on the flight funding within the next couple of days as well. I think just for you to know, we have been endeavoring very much to cover as many teams as we could. You can imagine that the accommodation itself costs an arm and leg, as well as the logistics, of course. But we are trying as much as we can to help the teams in need for flights coverage, the funding or the budget we have until the moment will not help to sponsor all teams, of course, but we are doing everything in our might to help those in most need. I think I have no further points on my mind, which brings us to the actual end of the session. Thank you all for being present today. I hope you've enjoyed the session, and be reminded that our next one will be on Sunday, 23rd of June at 4 p.m. Cairo time. Thank you for your time, your presence, and see you then.
Ciao. شكرا عبد الرحمن. سلام.